want to start with some caveats. First of all, of course, what I have to say is UK-centric. I'm talking about outward looking from the United Kingdom. And of course, it's a single view. It is entirely my view. It doesn't represent the views of chambers or indeed any other institution or organization with which I'm associated. And if I say something which you find a little jarring, then that's, I suppose, part of what I want to talk about, because I really want to make you think about some of the issues that I choose to raise. Although I work in these singular jurisdictions that I've mentioned, I want to try and make this as generic as possible. And I think that's important because we can establish a number of themes which have applications everywhere, at least in my view. Of course, my approach tends to be obviously barristerial, and English barristers are both old-fashioned, even anachronistic, and some people think that the use of a barrister is out of place in dealing with mediation, particularly as an advocate or party representative. What I would say is that the English bar is highly adaptable, and even if it gives the impression of being old-fashioned, I think the reality is that our approach to modern commercial, transactional and non-transactional business is very valid, because the bar brings three particular skill sets which are of great value to clients. Obviously, we're trained in critical analysis, we are asked to problem solve, and then communicate what it is that we have both analysed and decided is the way forward. But of course, we're working within a framework, the framework of both procedural law and substantive law, according to the jurisdiction in which we operate. But when you apply it to mediation, then the circumstances are very different, and the bar has to get involved in working with clients on much more of a teamwork basis, including allowing the client to lead in circumstances where the mediator is much more concerned with what is of importance to the client rather than importance to the lawyer, or indeed importance to the particular legal system. So the other caveats that I want to talk about are that, firstly, this is a snapshot in time, and it may be that in a year, 2 years, 5 years, what I'm talking about will seem very old-fashioned indeed and just out of step, because it's very difficult to see the way forward. I need to mention COVID, obviously. So commercial enterprises all over the world have been facing the kind of challenges rarely seen outside wartime. I mean, transport, oil and gas, supply chains, tourism, logistics, property, retail, hospitality have suffered the wholesale suspension of trading activities all over the world, in some places worse than others. But what does that mean? It means that the number of liquidations, personal insolvency, mass unemployment, and the scale of government intervention in combination will probably never have been seen before by anyone now living. So the enormity of potential problems now facing most of us pose questions in every sector concerning whether the conduct of business will ever return to normal, or will profound change occur with the way in which we engage with each other. We've already seen in the UK indications that there's been a significant breakdown in the civil justice system. All over the world, courts are closing, and all over the world, trials have been deferred, delayed, cancelled. And the reality is, for mediators, and of course for those practicing mediation, we hope that this will be a significant jolt forward in getting people to engage with mediation as the way forward. And there's a good reason for this. You know, the role of the court in dealing with contracts is principally to give effect to the intention of the parties at the time they were entered into. That's the job of the court. It's not actually appropriate for the kind of response to the pandemic across the world that we're dealing with. And I think that in the short term, lawyers are going to be asked to consider the parameters of existing contracts. So, for example, ongoing liability for contractual performance, can it be enforced, or will liability suspended by operation of force majeure? Have contracts been frustrated? Will the parties take a commercially realistic view and renegotiate the contract? Now, we know for sure that the courts cannot help parties renegotiate a contract, and mediators can. And for those of you who have clients in a particular situation, certainly many of you will have clients who are either going to be saying, how can I secure payment, or how can I secure contractual performance? And on the other hand, you'll have clients saying, how can I avoid payment or avoid contractual performance? Because if I'm committed to it, then I'm simply going to go bust. My firm will be in liquidation, and that will be the end of the trading relationship. So for those of you who already understand the nature of mediation, what we try and do is trade out of our disputes rather than fight our way out of our disputes. We try and look at the broader picture of the way in which the clients are engaged with each other. And as lawyers, we simply have to ease their path in trying to protect the relationships, enhance it, develop it, rather than assist the clients in the problems which may lead to liquidation. So that's really where I'm coming from. And therefore, my other caveat is that as an audience, I have to assume that all of you who are attending have a basic understanding of the principles of mediation and sufficient experience to be dealing with international disputes. We've taken the view that although we want an interactive session, there are too many people viewing for me to answer questions and answers, save using the Q&A panel and the chat room. So both of those are available to you. It may be at the end of the talk, if there's time, I will open up the microphone so that people can talk generally, but I'm not sure that that's going to happen. But please raise questions if you can. I'll deal with them in the time available. I suspect that I'm going to be posing questions myself, and the answers are likely to be jurisdiction dependent. Okay, I've been asked, how can we get the slides? The slides that are going to be part of the recording. I'm being asked for Fatima. I see you're asking, how is mediation different to arbitration and conciliations, the differences between these three? And these are fairly basic questions. And the short answer is simply that mediation is not an arbitral process. An arbitral process requires the third party to be the decision maker. And in the context of mediation, it is the parties themselves who are the decision makers. They may be guided by their own lawyers or their own team, but the reality is the decision is theirs. And even if you're in a highly regulated jurisdiction where you are guided into a mediation, whether you like it or not, that doesn't determine the outcome. The outcome is still for the parties rather than for the mediator. I'm asked about conciliation. Conciliation is really a process where, although the parties still make the decision, the mediator or the conciliator is prepared to offer advice in respect of the merits of the settlement. Normally, a mediator would not be expected to offer advice or guidance in respect of the merits of the settlement, would leave it for the party, subject to what is being offered being workable and to an extent durable. By and large, mediation is far cheaper than litigation and arbitration, since it lasts for a much shorter period. So I'll come back to the other questions about the nature of enforcement of settlement, and I want to move on and talk very specifically about when you become engaged with an international dispute and what it is that you should be doing so far as mediation is concerned. So by way of introduction, can I just say this? If you do international work, you will almost certainly be bumping up against both jurisdictional and cultural issues. It's inevitable. And it probably goes without saying that if you're engaged with foreign lawyers on the other side of the case, then there'll be foreign clients from jurisdictions other than your own, and you will be forced to engage on a cross-border or multilingual or multicultural dispute basis. Now, there's a wealth of material available in conflict of laws and choice of law, and that's not something I propose dealing with today. And besides, for mediation advocates, those of us who are used to dealing with international disputes, it's fairly common knowledge the conflict issues that are likely to arise in the substantive litigation. What is important for the mediator and within mediation is the application of issues which are non-law issues. And how you apply these will be dependent upon your appreciation of the way the mediator is going to be moving away from strictly legal issues and introducing matters which may come from a variety of different fields. So, for example, it's quite likely that mediators who have an understanding of cultural differences will start off by looking at a socio-anthropological approach rather than purely legal approach. And they will look at technical professional work which revolves around the sector that the dispute comes from. But broadly speaking, these are generic matters which the mediator will bring together and apply in the course of the work that you're going to do together. And it's simply a question of having people from different cultures, different nations, different languages, all having had different commercial experience sitting in the room with you. I'm just looking at more questions as they come in. Okay, so yeah, I'm as I share the screen, the slides will come up. So I hope that isn't an issue. We've just been joined by Blazo Nejic, who I regard as the most important mediator in Serbia. Welcome from Belgrade, Blazo. In fact, I should say welcome to people who are viewing from India, from Nigeria, from the Netherlands, from Belgium, from Hong Kong, from Singapore, and from Turkey, Greece, and, well, I mean, we have a huge variety. I wish this was a panel discussion rather than simply you listening to me for the time being. Okay, so what I've said is it's important that you have an understanding of the need to engage on an international basis. Look, you won't always be attuned to the linguistic or cultural nuances of those with whom you are having a conversation, but you need to know and accept that they exist, and that the path to settlement is likely to require a moderation of your own values and your sense of being right. Now, as lawyers, we start particularly from the viewpoint, I am right. My process is the best process, my system is the best system, and I'm comfortable with the work that I do, and therefore I have a sense of the rightness of my approach. And I think that there needs to be something of a sea change when you come into a mediation and you have to engage with both foreign lawyers and potentially on a foreign jurisdictional basis. And the first thing you have to lose is, with respect, the arrogance of feeling that you are right and you need to be seen to be right. Mediation simply doesn't need to go there. And in any event, what you're really trying to do is to benefit your client. And if that means that you have to adopt a completely different approach to your advocacy or your representation skills, then so be it. You must let it go, and you must work out the best means of doing it and where to do it. For me, the starting point is an additional layer of preparation. You know, when you mediate in a cross-border or international dispute, there is a completely new dimension to what you are doing. And it requires additional work with the mediator beforehand. It may require additional work with the advocates on the other side beforehand, because building a rapport in cross-border work is very different from doing that in domestic work, simply because one of the parties is likely to be from the mediator's jurisdiction and the other party will not be. Now, whether the mediator is from your jurisdiction or from the other party's jurisdiction is really a matter for the mechanism by which you select the mediator. And it is much harder to work on or remove a perception of bias, and much harder work for the mediator to engage the advocates before the mediation starts. But I'm going to come on to that in a minute. The other thing, which I'm not shy of talking about, because I've seen it in many of the places that I've traveled to over the years, is that the political dimension may become heavily invested in what it is possible to do in a particular place. And of course, who you do it for. It may be that you are, on the face of it, mediating with a commercial party in a foreign state, but the government of that state, various state actors or state agencies have a vested interest in the outcome of the mediation unknown to you. That may be reflected in process issues. It may be reflected in what happens after an agreement has been concluded, because it may require ratification by persons that you did not know had to give authority in the process. But these are issues that we need to grapple with, and we'll talk about them time permitting. So, but this is as much part of the risk appraisal, the risk analysis of your case and your client's position. And an important point, of course, is going to be whether any settlement will be enforceable. Whether a money settlement is going to be contingent on foreign exchange regulations, therefore whether money can be taken out of a country. What a settlement in a soft currency is going to amount to. And the risk profile to your client may be elevated, whether you like it or not, as a consequence of both political culture and indeed general cultural issues. But of course, it may be an opportunity, where appropriate, to persuade your client, who might otherwise be locked in a foreign civil justice system, to get out of that system and into mediation. And then, of course, you have to look at the relationship between a jurisdiction and mediation within that jurisdiction, particularly if you're working in a regulated jurisdiction overseas. In moving towards mediation, you have to identify how tangible there is support for mediation in a foreign jurisdiction. And is it actually genuinely engaged, or does it simply pay lip service to mediation to get cases out of its courts, but it doesn't provide an infrastructure or resources? And what about resistance? Are you going to be dealing with either state or local or lawyer resistance to ADR, or judicial resistance to ADR? You know, if you're working in a foreign jurisdiction, are the judges generally favorable to the concept of ADR, or are they antagonistic? And these are questions which you may need to consider very carefully before deciding whether or not to mediate in a foreign jurisdiction. But I think there are three themes that we can deal with this morning. The first is jurisdictional aspects of cross-border mediation. The second is the impact of culture and language, and taking these two together, certain aspects of how mediation processes are likely to be affected by this. There are some degree of overlap, there are some common features. And finally, the third theme that I want to talk about is how is preparation different for a cross-border mediation? So I'm going to put up my slides. In fact, the slides, I'm afraid, are probably just labels for me, really. And they don't come accompanied by any notes. I'm terribly sorry, I haven't any notes for you, but I can tell you that my thinking in this area is going to be part of my next book, which is going to be called Advanced Mediation Advocacy, and should be out in October or November. And those of you who are watching from Singapore may recognize some of the things that I was discussing in Maxwell Chambers on my visit not that long ago. So, mediator selection, and in particular, what are the areas that we're looking for in terms of mediator selection? Now, those of you I'm going to take as read will have an appreciation of how to select a mediator within your own jurisdiction. And in particular, the nature of mediation in your various jurisdictions may be impacted by the regulation of mediation within those jurisdictions. In the United Kingdom, mediation is still almost entirely unregulated, and mediator selection is, in my view, a matter for the choice of the parties, and in particular, a matter of choice for those party representatives who are acting in the mediation. Broadly speaking, I call these mediation advocates. For the most part, they're likely to be lawyers, but not necessarily, because other professions, there's no such thing as locus standi in mediation, and therefore, I say that outside Italy, and I think Greece, but I'll be corrected if I'm wrong. But outside those two countries, no locus standi in mediation, and anybody can represent a party in mediation. So let's presume that what we're trying to do is to identify the kind of mediator that lawyers want. So we already know that for the most part, mediators are trained in a facilitative model where they will not intervene by offering their own opinion in respect of the outcome of mediation. But in terms of what a lawyer would want, I put up these 3 bullet points, and I think that what we're talking about in particular is issues arising out of the problem of bias in dealing with potentially foreign mediators. If I come down to style, then if we're talking about commercial transactions, then I think most lawyers engaged in mediation are still going to be anchoring what the client wants in the legal case, even though taking a step backwards may open their eyes to the idea that if there is much more for the client to gain by working collaboratively to find a solution to the problem, which is a commercial solution and not a legalistic solution, then it's open simply for the lawyer to recognize that mediators use different styles, and in particular, rather than worry too much about facilitative, or that they should be thinking more in terms of the degree of intervention or guidance that a mediator is prepared to give. Does this particular dispute require a passive mediator, where you get on with negotiating with the other side and the mediator has a light touch, laissez-faire approach, just intervenes to help guide the process and assists in a way which overrides cultural or linguistic differences, making sure that the parties have the requisite degree of understanding? Do you want a robust mediator? That's somebody who's interventionist or activist, or indeed advisory, which is more in the conciliator role. Question: how will this be seen or received from a cultural perspective? After all, we generally say that the meaning of a message is how it's received and not how it's given. And therefore, perception of the mediator becomes very important in cross-border work. So, for example, would it be more appropriate to have co-mediation? Co-mediation would enable the parties to have one mediator from each jurisdiction working collaboratively together and effectively helping to iron out the differences between the parties in a way that gives more client confidence to the process. Now, one of the things that we're concerned about, of course, is potential mediator bias, particularly if it is subliminal bias. Now, you may say to me, what does it matter? You know, the mediator is not the decision maker, it's the client that's the decision maker. And therefore, we have to allow the mediator to get on with his job. And as long as we trust the mediator, we shouldn't worry too much about bias. As an advocate, I've always expressed the view that once you trust the mediator, really nothing else matters. And the question of the perception of neutrality is only a perception. And I say that because when I'm working with a client, as far as I'm concerned, I want the mediator to be on my side. I want him to be working with me and my client to get the best possible deal available for my client. The fact that he's trying to do the same thing for the other side at the same time doesn't bother me in the least, as long as I trust him. But the mediation industry sells itself on the basis of neutrality and therefore would be concerned about the appearance of bias, particularly in circumstances where at least one of the clients is foreign to the mediator. So there is a risk, and the risk is that the mediator may display a cultural or educational or intellectual or even jurisdictional bias, where simply, naturally, and without even knowing they're doing it, the mediator gravitates towards the familiar. So in terms of legal system, he may gravitate towards a common law approach rather than a civil law approach. And he may gravitate towards Western ideas rather than Eastern ideas. And he may come from a jurisdictional tradition where the mediator only pays lip service to the empowerment of the parties and still regards himself as being in control of the outcome, even if he's not the decision maker. So there are core questions that need to be understood by parties and their lawyers in selecting mediators. And it may be, of course, that one should be less concerned about mediators and perhaps more concerned about the way in which you're going to engage with the other side, certainly from the perspective of how you're going to negotiate. But there it is. I think that labels are difficult, and I personally like to set aside labels anyway. Most clients would like to be guided in commercial disputes by some form of robust commercial decision making. And therefore we need to get rid of what the mediation industry tells us: facilitative, evaluative, normative, transformative, transitional. You know, the mediators create these labels, and these labels are an indication principally to other mediators rather than to the lawyers from different jurisdictions. So what I think we should be doing is to be guided by the degree of robustness that the client wants in guidance towards decision making. Question: have you chosen your mediator as a lawyer to be passive or to be more activist? Do you want him to be interventionist? Do you want the mediator to be advisory in the sense that you, the lawyer, can talk to the mediator privately and have what amounts to an advisory session, subject to the limitation of your own personal instructions? And if you're operating in a cross-cultural context, What is the mediator's cultural perspective going to be? Does the mediator have sufficient understanding of your culture, of linguistic cues that you are going to use? And I suppose the best way to try and describe it is to think that, let's say that you're, I don't know, wearing a pair of sunglasses, and you can change the filter. You can change the strength of the filter, the color of the filter, and therefore use lenses in a completely different way. And then engage with the mediator so that the mediator has a clear understanding of where you're coming from. And what you really have is a manager of a process where the process itself can be robust, even if the manager expresses laissez-faire qualities. So you really want a guide to process, and you want somebody who, whilst in control of the management of the process, allows the parties, and of course their lawyers, to have as much freedom as possible to allow the parties to do as much as they can by themselves. So he or she must be proactive, must be interventionist, and must have a strong ability to keep the momentum going. I want to talk about roles and responsibilities in international work, and I think some of what I say is really it overflows and is also part of mediator selection. And it's really to do with understanding whose responsibility is it to make sure that the client understands the process, the language in which the process is being conducted, and most particularly the settlement. Okay, most of this should be done by way of preparation before we proceed, before we start. And most lawyers and mediators should be working together in advance of the mediation. Why? Because one of the difficulties in cross-cultural work is in finding a settlement that is durable, that works in both jurisdictions, and that isn't going to fall apart the moment a party gets on an aeroplane, flies back and starts thinking about what has happened during the course of the mediation, and realizes that the settlement he's entered into isn't quite what he thought it was at the time. It's the lawyer's responsibility to ensure that that does not happen in partnership with the mediator. And you need, therefore, to have an appreciation of quite a number of different facets, which is why I say that working internationally causes you to overlay a significant number of other factors that you've got to take into account when you prepare. Jurisdictional, linguistic, sociocultural, historic, societal, business practice, monetary, value systems. You know, we must return to the basics. You know, everybody in the room has a reason for being there. And therefore, the mediator is going to be looking at participants, not just parties. Those of us who practice regularly in domestic mediation will know that for the purpose of mediation, you don't have to worry simply about in whom the cause of action is vested, who has the defense. You have to have an understanding of why the people in the room are there, what their agenda is, and how that fits into the whole of the mediation. We know from experience that people turn up in the mediation room and we are told as mediators that they're just observers. This is an observer from the company. This is an observer from the head office. This is an observer from the insurers. And the reality is they're just as likely to be decision makers as anybody sitting in front of them at the table. And it may be even more significant that the mediator has an understanding of who the parties in the room are and what their position, what their responsibilities are likely to be, even if they are not disclosed to the other side during the course of the mediation. So, what about access? the chances are that your client is not going to meet the mediator until the day of the mediation itself, but you must meet the mediator. I prepared my thoughts concerning this presentation before lockdown, and plainly there has been an enormous shift for those of us who are still practicing onto online platforms. Online platforms give us the ability to work remotely very, very cheaply. And by and large, the only cost is the cost of professional time. And therefore, I would encourage you to engage with the mediator using online platforms as early as possible, and to cover as wide a range of discussion as possible as part of your preparation. And there is no reason why, once the mediation agreement has been entered into, you cannot discuss matters going to the heart of the dispute, or other factors that concern you as the lawyer, but more particularly concern your client, with the mediator, so that the mediator covers as much ground as possible prior to the mediation starting. And one of the things that you have to understand is the nature of jurisdictional differences dealing in cross-border work. So, for example, the impact of the difference between a common law jurisdiction and a civil law jurisdiction. We pride ourselves as common lawyers in having great flexibility in our approach to problem solving, even within the constraints of the law, because the common law, it tends to be reactive to the problem in front of it. Judges, by and large, are trained to give practical justice to the parties immediately in front of them. And because of the flexibility of the system of precedents, they won't hesitate to try and find an intellectual argument which enables them to make sure that the party that they want to win wins. And if that means that their judgment is open to appeal on the law, then they will try and construe the facts in such a way that the appeal is unlikely to succeed. My cynical view, but actually it works. And one of the great things about the common law system, of course, is that the use of precedent means that there is consistency in the approach to judicial decision-making across the whole of the jurisdiction. The difficulty for us as common lawyers is, in theory, and most often in practice, I suppose, the law changes every day, which means that the client has no accessibility to the law and has to use a lawyer to find out what the law is. So, by contrast, of course, in civil jurisdictions, where the law is codified, then anybody can look up what the law is, because the basic principles will be set out in the code. It has a rigid structure, and you may think that that this means it's difficult to change, and that the courts cannot do immediate practical justice to the litigants. The reality is slightly different, because what you have are very considerable inconsistencies in interpretation across jurisdictions, which need ultimately to be reconciled at a Supreme Court level, or possibly at the level of the Court of Justice of the European Union. In mediation, this is simply reflected by the likely hinterland of where either the mediator or the lawyer on the other side is coming from in terms of approach, and it's worth thinking about. What about the impact of regulatory or non-regulatory requirements so far as the mediation process is concerned? So this is, you have to have an understanding of how does the mediation agreement bite in the particular jurisdiction that you're dealing with? Is it regulated? Is it an open market? What is the nature of confidentiality? Do you have a mediation privilege, or is it merely confidential, subject to the requirements of local law? What is the role of the mediator in the process itself? In a regulated environment, in a foreign jurisdiction, it may be that the mediator is responsible for the drafting of the settlement. Whereas in the United Kingdom, mediators are trained to have nothing to do with the settlement, if at all possible, because that's the responsibility of the lawyers involved. And authority to settle may be authority of the lawyers or of the parties or of other participants. I've already touched on ratification. And therefore that the authority issue is something that's got to be investigated with the mediator before you start. And then of course, control of the mediation environment. Is there true party empowerment? Or in fact, does the mediator have a much more significant role to play than you are used to in your environment? So we need to have a clear understanding of the process in which you're going to get engaged if it's not your process. And if the mediator is coming from a background where his process is slightly different. In particular, the model may be different. You have to have an understanding of whether most of the mediation is going to be within the confines of a private room, or whether most of the mediation is going to be in open session, and only unusually for the purposes of time out will the parties have the opportunity of speaking privately with their lawyer in closed session. And of course you have to understand whether or not the mediator is coming from a jurisdiction where they are comfortable with working in caucus with lawyers and parties on one side only. Core cross-cultural factors in terms of language and understanding. You have to, first of all, choose the language in which the mediation is going to take place. If that language happens to be English, and I say that as an arrogant chauvinist, of course, if the language is going to be English, then you've got to have a clear view of the mediator's own capacity to use English and the other side's capacity to use English, even if the mediator and the other side say they are quite comfortable in using English. I go to many places where people tell me that they are fluent in English, and there seems to be a difference between oral English and written English. There seems to be a difference in using business English and everyday English. One of the big problems that I come across is where native-born English speakers they use not slang expressions, but they certainly use idiom, or they use modern English drawn from contemporary expressions which fall out of use pretty quickly. And there's a real problem where either the mediator or the lawyer on one side is using English idiom, and the other side simply don't get it, or by the time they get it, the speaker has moved on to another subject, and therefore they've lost a point. It's vital that you carry understanding. And if that means reducing your vocabulary, changing your vocabulary, making sure that the other side have a clear understanding of what you're talking about, then so be it. It is extremely important. And there are issues here. You don't want to embarrass the other side if you suspect that their English does not extend to the degree of comprehension that you need them to have. The same goes for the mediator, particularly if you're dealing with a face culture and simply embarrassing them by pointing out their misunderstanding of English, or even expressing a concern for their understanding, may lead to embarrassment, may impact upon the relationship that you're trying to build with the other side. And you also need to have an understanding of cultural factors which feed into the expression of language. I mean, there is a very obvious example, a typical example, which is Japanese lawyers who are negotiating in English. Culturally, it's extremely rude in Japan to use no in a direct way. it's regarded as rude. And so the Japanese have evolved 15 different ways of saying no without saying no. And most negotiators have an understanding that if a Japanese says to you that something is difficult, that's the end of the negotiation. You know, a native English speaker would think they're waiting for a counter proposal, that there's going to be a modification of something. No, that's in fact the end of negotiation and the end of mediation. And you have to have cultural awareness of the use of language. And this is a conversation you need to have with the mediator. And it seems to me that it's very useful to have this conversation with the lawyer of the other side as part of your preparation. So you've got this obligation, it seems to me, to check both the mediator and the opponent's understanding and effectiveness of non-primary language. And you've got to ensure that your client and the other client understands what's going on, and particularly what offers are being made, without embarrassment. If you're going to use interpreters, make sure that the interpreters that are being commissioned, and they will probably be commissioned either by probably be commissioned by the mediator, but you need to have a say. You need to make sure that the interpreters are held to the same standard as native speakers because of the use of idiom and colloquialism. You need to know that the interpreter has a sufficient cultural awareness to be able to engage at the level of business language and of legal language, and of course things like humor. I was doing some work in Turkey where there were some very proficient, it seemed to me, English language interpreters. And normally I always have a casual conversation with interpreters to try and gauge the level that they're working to. And I can still remember that I said to them, look, I like to use humor where I can. And if necessary, I like to get the parties at ease by telling them a joke. And I said, and let me tell you the joke to see whether you can translate it properly. And I said the joke, and the interpreter said, yes, absolutely no problem translating that. I can translate that fine. And as I turned to walk away, he said, but tell me, why is it funny? And of course, to me, that's an immediate warning signal that he may have language skills, but he doesn't have cultural nuancing skills that may be completely vital in conveying a message. I'll deal with the questions in a minute. I hope I'm not offending people. I'm just relaying my own experience. I do think that it's vital that you say to the mediator, please do not use idiom, non-shared language, and try yourself and encourage the mediator to avoid uncommon legal and technical jargon. Now, settlement obligations. You have got to make sure that the mediator ensures himself or herself an understanding of the settlement obligations and their enforceability. Absolutely vital. Otherwise, you may be walking away confident that you've got a deal for your client, but your client, in fact, has got nothing. And this is particularly of concern in China. I suppose I could say a lot about China at the moment, but I hope you get the message. If you negotiate a deal in China, that's the beginning of the negotiation and not the end of it, sadly. Okay, now, dealing with your opposite number as part of preparation. Despite the difficulties that I have raised, actually, the starting point is that you can identify, firstly, the likely approach of your opposite number, depending on where he or she comes from. You'll know, I think, before you start, whether they are contentious or transactional lawyers. you can ask or find out really by looking at their website, whether their approach is competitive or collaborative, cooperative, because it will say so. And if you discover they're not being the way they say, you can say, well, wait a minute, on your website it says you're cooperative. You're not being very cooperative at the moment. Well, you get the point. But what you can do, of course, is you can use the fact that there is an esprit de corps, fraternity amongst lawyers. And we share values and we share professionalism, and you should be able to call lawyers on the other side to that professionalism if it's necessary to do so. And you should develop cohesive issues between the parties through collaboration, or at least if not collaboration, then certainly cooperation, so that you're using the mediator jointly as a tool to bring the parties together as a catalyst. And that is probably the most effective approach. And there are benefits of having a cross-cultural approach to the subject matter of the dispute. First, it reduces or at least eliminates suspicion of miscommunication. It means that you can survey what the parties' objectives are, what they want to try and get out of the mediation. It tries to reduce risk by enabling you to attach a value to your client's preferred choice and a value to the choice of the other side. And your selection bias is reduced through the information that could be exchanged, and indeed the availability of a plan towards the outcome which is desirable. Be careful about the culture that may have an impact in respect of the attendance of your team. Who is going to attend? You've got to make sure that it's appropriate for that person to attend. The role of dress. Dress may be a very important cultural issue to take up with a mediator. The role of women, the precedence within teams. If you're a mediator, you'll already understand the importance of seating arrangements. But the order of precedence of address may become extremely important, because you've got to deal with face. If you are still traveling, there may be issues in respect of food, custom, and the way in which you address people by title. You need to learn modes of address for foreign culture and make use of it simply as sending a message that you have taken the trouble to find out about the other side. Firstly, it puts them at their ease, and secondly, you're gaining respect for yourself. You have to add value as a lawyer. Now, normally, when we talk about adding value in mediation, certainly on a domestic level, you'll be undertaking the same sort of thing that you would normally expect to do. So you have competency, so you know what to do. You're able to demonstrate to the client that you're competent. You've got to work with the client, because you're the mediation representative. You're not just a lawyer. You can't say to the client, I'm sorry, I can't advise you on business decisions. You've got to work with the client, particularly in dealing with international transactions, to have a clear understanding of the nature of the client's business and the importance of this kind of transaction. And in particular, you need to understand the importance of whether to try and save the relationship and what that's going to cost. You need to show leadership where it's appropriate and not be marginalized by the mediator, but equally where you can take a step backwards, that's an important thing to do. And you may be involved in offering a skill set in place of advocacy, because you're not engaged in traditional advocacy. You have to have an understanding of tactics, and this really requires you to be acting in a quite a sophisticated way. And in terms of your preparation, get down to the specifics of what is needed. You have to have a sufficient understanding of the process. And in particular, if you need to ask questions of the mediator about the process, don't feel shy in doing so. You need to have a clear understanding of your client's business and the context of the dispute, the client's desired outcome and what his or her or its flexibility may be. And of course, this sits on top of preparation of the legal case so that you can offer advice as appropriate. Because irrespective of anything else, mediation still requires you to give continuity of legal advice. It requires you to give advice which is consistent, and it's got to enable you to find a balance between legal advice which is appropriate in the face of reality testing and the acquisition of new information. And of course, you've got to work with the client to build the BATNA. So when I say that, what I suppose I'm talking about are questions that you really need to answer before you even getting involved with the mediator. Questions which form part of the usual process, I'm sorry, I'm looking for a note, by which the mediator and indeed the client come into the session. So for example, you have to have a clear understanding of what it's going to cost your client if you can't get a deal. You have to understand the commercial value of, or commercial impact of failing to get a deal. You need to know what the costs are going to be so far as you're concerned from the day the mediation fails to the day you get not just judgment but execution. You have to be able to advise all of the client of the cost-benefit analysis of continuing with the legal proposition. You have to know what's the value to the client of his time and his other direct costs. Is there a better economic use for that time rather than litigation? Can you calculate what it is? What is the client's ambition? Does he want to keep trading with this party in a foreign country or not? Does he want to keep the relationship going if possible? And what is the best way of doing it? What is the likely cost to the client of fracturing the present relationship? And what other factors need to be taken into account? They may be reputational, they may be social, communal, they may have an impact on a particular neighborhood or sector, but reputation can be microcosmic as well as macro. And there may be cultural issues that have an impact on failing to get a deal. And you have the responsibility of working in putting all these things together with the client, even before you speak to the mediator, or in conjunction with questions that the mediator may be asking you from a cultural perspective and from a perspective of ensuring that your client has an understanding, again, before the mediation starts. You have to understand the nature of your client's authority to settle. If your client is working in a large institution, you've got to understand the sufficiency of authority, and you need to understand the nature of the authority on the other side and not be taken by surprise if it doesn't appear to be what you thought it was at the outset. Now, I'm planning on going on for another 5 or 10 minutes because I want to cover these last few things that are on the list. And what I would like to do is, I'm going to deal with these questions at the end of the session, I think, and mainly because they're coming from one person. Let me tell you quickly about enforcement of settlement agreements. Historically, one of the big difficulties in dealing with international mediations is the nature of outcome. You can walk away with a settlement which appears to give your client everything they want and they can be extremely pleased. But of course, what happens if there is a breakdown in respect of the outcome because the other side hasn't or decides not to perform? And either there is a volte-face or the client really didn't intend to do what he promised to do at the mediation, and was just saying that for the purpose of preserving face in front of your client and the mediator. So I think you need to have a clear understanding of the nature of the jurisdiction before we start. So, for example, most jurisdictions will provide you with a settlement agreement that amounts to a contract, and it's a contract which replaces the dispute, and that's certainly true of the United Kingdom. However, there are a number of jurisdictions where the settlement agreement amounts to an immediately registrable judgment in the court, which can be enforced without it being broken. So you register the settlement as a judgment, and I can tell you that absent one or two jurisdictions that I really don't know about, if you're mediating in Belgium, Bulgaria, Croatia, Denmark, Estonia, Finland, Hungary, Lithuania, Luxembourg, Malta, Poland, Romania, Slovakia, Ecuador, India, Indonesia, or Japan, the chances are that the settlement agreement will be registrable in the courts and can be enforced immediately, whereas virtually everywhere else, you end up with a contract which needs to be broken before the settlement can be enforced, and then the settlement enforcement procedure will be the subject to local jurisdiction. Now, because of that, large multinational corporations have shied away from using mediation thus far and have contented themselves with either using arbitration, which of course is expensive and lengthy, but it has the benefit of you being able to choose the arbitrator. It's a confidential process. And of course, the award is portable in the sense that because of the New York Convention on the Recognition of Arbitral Awards, 1952, something like 140 countries will take your award and register it in their courts for enforcement using the usual processes. Two things have happened since. Innovative processes were developed in places like Singapore, where mediation proceeded as far as settlement and then was converted into an arbitral award which could be registered for enforcement. And there were various modifications. We had ARB, Med-ARB, or Med-ARB. But now we have the Singapore Convention on August the 7th, 2019, 46 states, including the United States, China, India, and South Korea, signed the Singapore Convention, formerly the United Nations Convention on International Settlement Awards, resulting from mediation. 3 countries which are sufficient have now ratified the Singapore Convention, and it will come into force on the 12th of September this year. And it provides for the resolution of, it provides for the enforcement of cross-border mediation awards, settlements, by making them registrable and enforceable pretty much in the same way as the New York Convention. Now, the United Kingdom and no other member of the European Union has signed the Singapore Convention, but it's quite likely that we will do so at some point in the relatively near future after January, and it's quite likely that the European Union will sign up as well. It takes time for international conventions to add signatories, but I suspect that in the course of the next 3 to 5 years, there are likely to be well over 100 participants. And this is intended to change the face of international mediation by giving commercial organizations much more confidence in both trading overseas and using mediation as an effective mechanism to resolve disputes. we're going to see a lot more of this as a result of the pandemic. And I hope that in the very short time available, I've given you just a hint, a broad brush hint on the things that you need to do in respect of how to approach international mediation. Very happy to take emails in respect of this. My email address is on this slide. If you haven't got the slides, agoodman@onechancerylane.com. If you want to know more about mediation advocacy, please have a look at the website of the practice group that I run, www.scmastandards.com. We have a monthly online conversation about contemporary issues in mediation on the second Monday of the month. The next one is going to be Monday the 10th of August at 9:30 British Summer Time for an hour. For those of you who are following the One Chancery Lane weekly online webinar series, next week Dominique Smith will be talking about cosmetic surgery claims from a clinical and legal perspective, and she'll be joined by a consultant cosmetic surgeon. Should be very interesting for those of you who are either practicing in that area or have nothing better to do. But I'm sure that's going to be very good. The standard of our webinars, absent this one, has been very high, and they're all available on our YouTube channel. Those of you who need to depart, thank you very much for attending, and I look forward to seeing as many of you as possible, both in my travels and online. And thank you very much indeed. I've got a number of questions. If I can take the questions. Do I think there are parallels between the Singapore Convention and the New York Convention? And I think the answer is that they're certainly intended to be. I think that the starting point for the framers of the Singapore Convention was the New York Convention. There are obviously a number of caveats. The convention is intended to apply to any settlement agreement that has resulted from mediation, that relates to a commercial dispute, that is writing, and that is international in character. So in order for a settlement agreement promoted by mediation to be international, at least two parties to the settlement must have their places of business in different countries, or if it's a state party, then the state with which the settlement agreement is most closely connected must be different from the other party's place of business. In fact, you don't have to be a national or have a place of business if you are a state actor. However, and I think this is important, the convention does not apply if the settlement agreement has been concluded or approved in the course of court proceedings, or is enforceable as a judgment of that state, so the list of states I've already mentioned, or is enforceable as an arbitral award, so that knocks out the Singapore Med-Arb or Arb-Med-Arb approach. There are some pitfalls in the Singapore Convention. If you're particularly interested in this, not only is there a plethora of material about it online, but because the convention is actually coming into force on the 12th of September, I can tell you that as part of the anniversary of its signature in August, the Singapore government has commissioned a lot of activity online in respect of the convention. So there's going to be a lot of free material for people who are interested in the convention. And in fact, you either need to, I don't know whether it's publicized yet, but you can either go to the Singapore government website or the various organizations in Singapore that promote mediation, including the Singapore International Mediation Institute, who I'm sure will be coordinating government activity in promoting it. Question, has Brexit affected ADR? Funnily enough, it has. We have very much under the wire and very quietly, we have left the European Directive on cross-border mediation. And this was one of the first things that our rather secretive Henry VIII committee reviewing European legislation did. And I don't think it's got very wide publicity. The fact of the matter is we are up in the air as to jurisdictional alignment after January the 1st. I know that the particular concern of the British government is that none of our jurisdictional activity should be under the supervision of the Court of Justice of the European Union. If we sign up to the existing Treaty of Lugano, then even though that would be very convenient and it would enable us to continue the Rome I regulation, Rome II to an extent, ultimately difficulties in interpretation and rights of appeal would eventually lead to the CJEU. And that's something which is politically unacceptable to the British government. And under those circumstances, it looks as if there will have to be some kind of bilateral treaties involved in the mutual recognition of jurisdiction, of which ADR is going to have to be a part. Until the UK signs up to the Singapore Convention, then ADR provisions, I think, are going to have to fall in line with the New York Convention on Arbitration. And therefore, we may be in this rather peculiar position of, again, have to artificially convert our mediation, cross-border mediation settlements into arbitral awards. I expect that there will be proposals published by September, October the latest. I would have expected to see something before now, but I dare say the government's got other things on its plate at the moment. I'm asked, let's just have a look at what else I'm asked. Is the decision by the mediator, arbitrator, or conciliator binding? The arbitrator's decision is binding and enforceable in court. Mediators and conciliators, as I hope I've explained, do not make decisions. The parties make decisions. And if the decisions, that is the settlement, afterwards come to be challenged, then there are issues about what can be said in court about what transpired during the course of the mediation or the conciliation. And the mediation industry is at pains to protect the confidence of what happened during the course of the mediation or conciliation. Firstly, they do it contractually. And secondly, they rely on the civil justice system of the particular jurisdiction to protect ADR as an entity. If parties do not have confidence in the confidentiality of the mediation room, then they will not use it. And this would have very significant consequences for those many countries that now see enormous backlogs, even beyond normal, in their caseload, and are trying to get as much shifted into mediation as possible. So there's going to be a development in many countries which extends confidentiality in mediation into a privilege which vests in the person of the mediator. At the moment, when parties enter into a mediation contract, there will always be a provision which says that the mediation is confidential and nothing that, no information that derives from the mediation or documents prepared for it are admissible afterwards in litigation. Of course, there may be issues about undue influence, economic duress, misrepresentation, which find the settlement agreement under impeachment in a court. And under those circumstances, there's always going to be a tension about what is in the interest of justice and protecting mediation as a concept. The mediators, I think, are very plain. They are not compellable as witnesses, and most mediators, quite frankly, are trained to forget their mediations, so that if they are forced to go to court and they are cross-examined either by a judge or by a party, they can say, hand on heart, I'm terribly sorry, I've destroyed all my papers and I forget. I do so many mediations and so much other work. I only have a vague recollection, and it would be wrong for me to try and give evidence to the court of something that may or may not have happened or have been said. That's the way we deal with that. I think I've dealt with different types of jurisdictions so far as this has been concerned. What examples can you provide for cross-border cases? Certainly trading arrangements, in investment in property, and therefore commercial landlord and tenant, supply of goods, supply chain management, shipping, probably the aircraft industry, personal injury disputes, claims arising out of people traveling abroad, either on holiday or for work. Any area where you can envisage that there will already be a conflict of laws issue will give rise to the same kind of considerations that you need to have in respect of mediation, with everything that I've talked about being an added layer on top. I hope I've covered tangentially the kind of challenges that a mediator face, and I'm asked, are there any existing books on international or cross-border mediations? There are. I think anything that's available at the moment you can get on Amazon, although it's a little bit pricier. I'm asked which UK court level is it enforceable, and the answer is that's simply a matter of domestic UK jurisdiction, depending on the value of the claim and the specialist sector in which the work, the dispute finds itself contextually. I hope I've dealt, Fatima, with all of your questions in respect of enforcement. Nothing by way of chats that are left over. We still seem to have 25 people on the seminar. I'd like to obviously just thank all of you who've spent your time with me this morning.